Honorable Janji?
Yes, Chair. I support your proposal, Chair, and I'm happy because I was going to raise the same thing. We have the written submission, so we'll consider the written submission. It does seem that they are not ready, and they shouldn't be shifting blame on us in that way. Can I also ask that Mr. Jeremy Acting switches off his mic? Because I think it will be disturbing. Thank you, Chair.
Thank you very much, Honorable Janji. Honorable Acton, can you switch off your mic just for a few minutes?
I'm just trying to find out how to do that.
Okay.
If anyone can advise me.
Committee Secretary.
Unmute.
Yeah, just unmute. Yes, thank you very much. Honorable Nubo.
Yes, Chair, I support what the Honourable Chairperson has said. The Doctors for Life, they have until tomorrow to make a presentation. They should have been presenting today, I see on the program. So maybe, they can do it tomorrow if they want. But as said, we also have their written submission, so we will consider that as well. So I agree with your proposal. Thanks, Chair.
Thank you very much. Honorable Horn.
Yes, thanks, Chair. I also agree with your sentiment and the way forward as proposed. Thanks.
Thank you very much. Honorable Swart.
Chair, morning to you and morning to colleagues. Firstly, I joined a minute or two late, so I wasn't able to tender my apology. I mean, no disrespect to any of the submitters, but I am in debates this morning from 10 o'clock and again this afternoon, if you'll accept my apology.
Okay.
I would like to have given Doctors for Life more time, but I do appreciate the conundrum that you're faced with. And I would tend to agree that they have got until tomorrow and that we do have written submissions. And as we know, although it's not necessarily permitted, but we do know that participants do add or send in additional submissions. Whether we consider that or not is a separate issue. Chair, so that is my view on that issue. May I also raise a second issue as we go into the public hearings, and that is for you as Chair to be mindful that there are some, and this is a very emotional issue. I appreciate that from many of the submitters, but I'm sure you will urge all participants to be respectful to Parliament and to you as the Chairman. I remember the last public hearings we had, there were some very distasteful comments were made towards the committee and you in particular, and I hope you'll be very firm on that. And it could be that you disable the chat if there isn't the necessary respect towards Parliament and the process that has been. We've been very, very patient with the process. And I would just urge in that regard, Chair, that all participants respect the process of Parliament. Thank you, Chair.
Thank you very much, Honorable Swart. I think everybody on the virtual platform is listening to you. Your comments are noted. We will act accordingly to guarantee everybody's right to speak and everybody's right to be heard, but also everybody's right to be respected. Thank you very much, members, and welcome to everybody, especially to the presenters and the organizations that have decided to take this opportunity to assist the process, to assist this process by making comments. We are aware that we were inviting comments for a specific clause that deals with the commercialization of hemp. We would really like to get members of the public commenting and guiding and assisting the process in as far as that is concerned. But we would not stop a person who will talk about other things. But the issue is that we have 10 minutes for each member or organization to make a presentation. Then that will be followed by questions and comments from members of Parliament, and we will proceed to the next presenter. Thank you very much. Welcome, Mr. Acton, Jeremy Acton.
Good.
Um,
Can you hear me?
Yes, we can hear you. How are you today?
Fine, thanks, and yourself.
Thank you very much. Sorry for this delay. We expect that we must deal with the housekeeping issues first. Thank you very much. You are welcome. You have 10 minutes.
Okay, to the Parliamentary Portfolio Committee and the President of South Africa, I'm Jeremy Acton, founder and leader of Icela Lensango, the Dacha Party of South Africa, which promotes cannabis as a resource for an inclusive, sustainable economy and for the health of people. I'm also original litigant in the Western Cape Constitutional Dacha case 4153/12 Western Cape High Court, which combined with Prince Ruben and others ultimately reached the Constitutional Court judgment in case 108/17 CCT on 18 September 2018. I'm fully informed regarding the 2023 draft cannabis bill, which now also features hemp clauses and also clauses regarding cultural and religious use of cannabis. I'm fully informed about the health-giving benefits of cannabinoids from cannabis sativa. I know that these plant cannabinoids enhance and enable the human body's endocannabinoid signaling system, and that cannabis dacha is a health-giving plant, whether taken as recreation, nutrition, prevention, or medicine. I'm fully informed about the nutritional value and health-enhancing value of the seeds and seed oil of cannabis. I'm fully informed about the fodder value of the stalks and foliage of cannabis. I'm a member of the Dacha culture of South Africa, which was prosecuted and persecuted by the state since 1923 until the Constitutional Court judgment in 2018 and ever since. And I inform you that the present draft cannabis for private purposes bill is rejected in total by myself and the Dacha culture of South Africa today. And the bill shall be adamantly resisted. And the bill in its present form is outside the mandate of the judgment and must be completely revised before tabling to Parliament to accord with the Constitutional Court judgment and basic human rights upheld in the Bill of Rights. The bill is rejected and vetoed by myself as litigant in case 108/17 CCT. The bill presumes that it may prescribe to the realm of human, individual, and family privacy, and falsely presumes that it may prescribe minimal and arbitrary quantities of plants that may be allowed to be grown. But I inform you that the decision on the number of plants in cultivation is a private personal decision of a person in accordance with their private personal assessment of their private cannabis needs, and is outside of any prescription by the state. So get used to it. The bill uses criminological and prosecutorial methods to regulate in the bill with a clear intent of criminalizing people instead of providing real guidelines for values, ethics, and method of establishing a constructive, equitable, and inclusive cannabis industry in South Africa. The bill attempts to severely limit people's access to the known benefits of the cannabis plant, and in the consideration of trafficable quantities for which a person can be prosecuted even if they're not trafficking. The bill, on the one hand, considers cannabis sativa to be an undesirable dependence-producing drug, but at the same time appears to recognize the industrial hemp fiber and nutritional value of the seed, but for arbitrary reason indicates that seed and fiber may not be harvested from high THC plants, which is ridiculous. The bill makes unsubstantiated claims that cannabis imposes harms on society and does not acknowledge that policing and prosecution as a form of regulation in the past and in the future is malicious and costly and harmful to individuals and the state. In the hemp sections of the bill, the Minister of Justice and Correctional Services attempts to appropriate like a gangster the cannabis resource for himself and make himself the sole decision-making and licensing authority and determinant of policy in the cannabis industry hemp sector. And this assumption of being sole decider is totally rejected by myself and by the Dacha culture of South Africa, who shall as a whole be the ultimate and sole decider of the future of cannabis sativa in South Africa. The bill fails to allow for the use of indigenous high THC landrace cannabis to be grown as cannabis for industry and cannabis for nutrition and for craft and tourism purposes. The bill unjustifiably gives the Minister of Justice the presumption he may regulate and monitor cannabis use in relation to the cultural and religious use. And this is a further attempt to control realms of decision in society that are generally protected from state interference by rights upheld in the Bill of Rights. The bill will promote the misuse of police informants, destroy people's rights to privacy, enable home raids to count plants to determine compliance, and generally abuse the rights of the people of South Africa. The bill enables the further development of a police state and the removal of human rights in the Bill of Rights. The bill promotes the criminalizations of citizens for a beneficial health-giving and wealth-giving plant that should be the natural human right of all humans in nature. The bill is being used to enable the breathalyzer testing of THC for drivers with arbitrary blood level limits imposed in an attempt to invade the inner bodily privacy and dignity of the cannabis user. And the bill aims to criminalize a person before they even commit any driving error and break the rules of the road, based simply on a person's use of cannabis as a measure of unfair discrimination. Such testing is not supported by any accident statistics that indicate that cannabis is a cause of road safety issues. The state is not able to show the need for such testing. Such testing is a violation of everybody's constitutional rights, and I call you out on your agenda. The bill does not recognize that a private vehicle is a personal private space that moves on a public road, and the bill criminalizes the smoking of dacha in a driver's seat of a vehicle while it is parked. And I say that these provisions are an intentional attempt to further erode privacy rights without substantiated reason. Although the bill defines a private space, it does not deign to recognize the definition of the term private or privacy, and thus pays no respect at all to the spirit and dictionary definitions of such concepts. The bill makes the South African Police the agency of enforcement of the bill. The bill SAP, with its widely justified public perception of being the most corrupt government agency in the nation, is also widely reported in the press as being infiltrated by criminal gangs. And the SAP is infiltrated, indeed controlled, by the organized prison gangs. And this is the force that the minister is going to send into homes to count plants. No way. The people of the dacha culture still to today suffer nationwide SAP raids on private cultivation by aggressive and abusive police members who conveniently do not wear name tags and seldom use a warrant when they enter. And when they gain entry, all cell phones, cash, and personal valuables are stolen. When the person is released on bail and returns to court for the next hearing, the victim is told that the case has been withdrawn and there's no need to appear. And the victim is unable to recover his property and cannabis. This is a racket now being run by the South African police along with the operating prosecutors, and we will not allow the bill to bring more police into our homes. For these and other reasons, I inform the committee, all ministers and the president that the bill will cause harm to South Africans and to South Africa as a nation. Real people are going to get really hurt if this bill is passed. The Cannabis for Private Purposes bill is a declaration of war, a fascist, totalitarian, authoritarian drug war Mark II upon the cannabis plant and the dacha culture of South Africa. In fact, all South Africans. And be advised that we do not meekly accept the tabling or signing of the bill. The Parliamentary Portfolio Committee has not heard the constructive criticisms and concerns of civil society in drafting the bill, and therefore has not done its job and must entirely revise the bill before tabling it to Parliament. I and the people of the dacha culture shall adamantly defend our privacy, our homes, our rights, our cannabis plants across the nation, and support each other against any such onslaught and the Cannabis Private Purposes Bill. Various members of the Parliamentary Portfolio Committee has made much mention of the obligation to international obligations in drafting the cannabis bill, but have totally ignored the imports of concerned civil society interested in affected parties, and have ignored the parameters of the dacha judgment in the case 10817 CCT, and are disregarding rights upheld in the Bill of Rights. The Portfolio Committee for the bill and all ministers and president are hereby informed that I do not contract with the bill, and there is no broader social contract with the bill. And I, as an original litigant and the people, dismiss and veto the present 2023 draft of the bill. And in view of the fact that this bill arises from litigation in the Constitutional Court, to which this bill is answerable, I warn that all parties who either table this bill in its present form or vote for its adoption in the House of Assembly, or who sign it into act, will be charged with contempt of the Constitutional Court judgment 108/17 CCT of 18 September 2018. End of verbal submission. Thank you.
Thank you very much, Mr. Acton, for your presentation and for responding to the call to make comments. Members, that is the presentation from Mr. Acton. Are there any questions or comments? Honorable Yako.
Chair, sorry, the technology always gets me. I just want to understand from the previous speaker, basically what does he recommend that we do at this point? Because the bill is here. So what is he recommending that we do? Do we just scrap the bill altogether? Or what is his suggestion on our way forward as a committee?
Thank you very much.
I believe
Honorable
that, if I may reply, thank you for the question. I appreciate that. It's a very constructive question. I believe that we can create a regulatory document which lays down policy and the way to unfold this cannabis resource for the benefit of all South Africans. The present bill actually cements the control of the bill more for the benefit of licensees as granted by the state. Whereas we have citizens of South Africa who in poverty, in the homelands, former homelands that have this cannabis, and then we need to help them to turn this into something of value and not just the narcotic recreational use of cannabis. So I have, for my own political party, the Dagga Party of South Africa, started writing my own policy and my own bill. And there hasn't been a platform for people to actually suggest real drafted lines in the bill. The preamble, which presumes to prescribe amounts of regulated plants, it's already invading privacy. And when the state regulates the private realm and invades with the booted police coming in, you're using the wrong agency in this bill to regulate the plant. It's from a criminal justice system, and it is criminal, and it's not justice. Okay.
Thank you very much.
So I would like to be able to submit the way, and you've heard many ways in which this can happen in a less police-orientated approach. I believe that the Minister of Justice is the completely wrong person to regulate this entire resource. And it should be open to democratic structures, not just one minister.
Thank you very much, Mr. Acton. Honorable Masako Chale.
Thank you very much, Chair. I think I'm quite confused a bit, because where we are, Chair, we are at the point where we are dealing with the part, only the part that we are requested to deal with. The opportunity, the presenter, I'm sure what he's talking about now was supposed to be addressed in the public hearings, the first ones, those that we conducted here. I'm not sure, maybe I'm confused, because now we are addressing even the issues that maybe we have addressed in the first period when we're dealing with this issue of cannabis. Chair, my question
to Mr. Chairman, if I may reply.
Sorry, we are going to reply. She has not yet done with her question.
Okay.
Yes, my question is that was he not aware about the process when it started? Because this process, as you indicated, Chair, it started even before us. So my issue is that, Chair, can we stick on the mandate that we not, in fact, let's not open it. Let's stick on the part that we have to deal with it now, which is commercialization of this. I'm not sure how he feels, because where we have dealt with those issues, Chair, as to the role of the minister and who's supposed to do what in this matter. Thank you, Chair.
Thank you very much.
May I reply?
No, I think No,
Mr. Chairman, I just want to point out that none of the complaints of the
Acton,
people who
Mr.
made
Acton,
submissions
Mr. Acton,
have been incorporated
Mr.
into the
Acton,
bill.
Mr. Acton, I am going to tell you when to respond. We are now going to take questions from other members, then you will respond. Honorable Swart.
No, Chair, thank you. And thank you to Mr. Acton, although I found your presentation quite disrespectful. But what I do want to say is we too have a number of concerns about the bill, obviously from a different perspective. And I would encourage you, maybe you could just, even if it's in another written submission, focus on the positive elements of the hemp and where you might have concerns about the number of plants and that policing aspect from a privacy perspective. I think those comments are helpful. But I do think that to use words such as veto, laying charges of contempt does not help your case. You are a leader of a political party. You know that it goes about representation in Parliament, which you sadly do not have. And so you're welcome to continue with those processes, but it doesn't help your case to threaten members of Parliament and in that regard. But I would urge you to focus on the concerns which a number of us have been raising over the years, and maybe help us with this very issue of commercialization of hemp, of medicinal, given your experience in this issue, given your experience as a litigant, and which can be helpful to the committee. And of course, going forward, there will be further hearings as well in the National Council of Provinces. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Yako, is that an old hand or a new hand?
Sorry, Chair, it's a new hand.
It's a new hand.
Yes.
No, let me first get responses before we allow you to come back.
Before your response, Chair, I think he might answer also all of it.
Okay.
It's just a small question. If the Dagga Party is saying that the Minister of Justice is not the person to regulate this bill at this level, who then is the person who would regulate it? If they say they are going to would rather have a regulatory document, who would then monitor the document and make sure that it is proceeded or it is adhered to properly, if it's not the Minister of Justice? Thank you, Chair.
Thank you very much. Mr. Acton, over to you. Mr. Acton.
I think he's on mute.
But he is on. Yes.
Hello, I'm sorry, my phone was on mute. To reply, I believe that the relevant departments are more likely to be the Minister of Trade and Industry, the Minister of Agriculture, the Minister of Social Development, and there was one other minister, but we have to rather remove it completely from the police and prosecution's mindset into the constructive creation of an economy centered on this resource kind of mindset. I also just wanted to reply, if I may, to the lady who asked about, let's just keep this to the hemp clauses. Unfortunately, our concerns about numbers of plants and realms of privacy and invasion have not been dealt with by the draft bill that was circulated for the comment on the hemp clauses. And so the bill is flawed from the preamble onwards. And that's why we're asking for a complete reconsideration of the process, the means by which we draft the social contract. You can't create laws which criminalize people who have never agreed about the law. So this is going to be a new way forward for an interaction between the public's knowledge of cannabis and the state, and trying to create a resource that can be unlocked for everybody. And why licenses if it's for everybody? Okay, so all of these things need to be rethought. And we are South African citizens. We're not to be viewed as potential criminals or criminals to be prevented. We are just humans trying to get a life. And we've got to be respected by the state in order to, and our privacy respected by the state, in order for this to even be called a private purposes bill. Okay? Because bill and private are actually two mutually exclusive concepts. Thank you.
Thank you very much, Mr. Acton, for participating in this process. Your views are going to be taken into account and responded to when the department makes its responses, and we are still going to consider them before we finalize the bill. Thank you very much for making the presentation.
Thank you very much.
Thank you. The next presenter is the Rastafari National Council. Rastafari National Council.
Greetings. I'm listening. The updated document said the Rastafari National Council presents tomorrow. I think Mr. Ramano revised that, so they are ready to present tomorrow, not today. It was duplicated. Please, Mr. Chairman, just check with Mr. Ramano.
Mr. Ramano, can you flight the updated program? Or also just WhatsApp me the updated program? Kosato.
Thanks, Mr. Chair.
Thank you very much. Thank you for assisting us. Kosato.
Morning, Chair. Yeah, I can present now if you want.
Good morning, Mr. Pax.
Good morning. Yeah, let me just upload our presentation quickly. Just 1 second, Chair.
In the meantime, Mr. Ramano, can you send me the updated program via WhatsApp?
Yeah, I can start, Chairperson, if you want.
Yes, please do.
Okay. Good morning, Chair, and good morning to members. Thanks for giving Kosato just some space to make some comments on the additional revisions to the bill. I think we do want to appreciate that the committee has really gone out of its way to provide for public participation. I think this will be our third presentation on this bill. And yeah, I think we just want to appreciate that. So I think for Kosato, Chair, I mean, we have an interest in these matters because we have members who are police officers who are doing their level best to uphold the laws passed by Parliament, etc. I think we also have workers who work in the pharmaceutical industry, health workers, and of course, workers like anybody else may want to consume these products for medicinal or religious or other purposes, etc. So, Chair, I think we want to, as Kosato, to welcome the bill and the further amendments proposed by the Portfolio Committee. We do support the passage of the bill in principle. Well, number one, to address the Constitutional Court directive to legalize cannabis and to provide a legal framework for the legal cultivation, the sale, and the consumption of cannabis and related products. So I think we do want to welcome and appreciate many of the additional provisions provided for in the latest revised bill by the Portfolio Committee. Chair, we are, however, concerned about some of the clauses which we believe continue just to seem to reflect a level of contradictory positions in government, in different departments or ministries, whether cannabis and its use should be legalized. Whilst Kosato has got some concerns about some of these clauses, we nonetheless believe that Parliament should pass the bill. We're saying that, Chair, because as imperfect as the bill is, we are rapidly running out of time to do so before the 2024 elections, and in order to meet the timeframes of the Constitutional Court directive. And Chair, we might think that the 2024 elections is in April next year, give or take 90 days. But looking at the parliamentary calendar, we have actually less than 6 months to do so, and this must still go to the NCOP, and must also hold its own public hearings in that regard. So the time really is rapidly running out. Chair, I think the areas of support from Kosato's side for the provisions in the bill we think are those that the clauses that seek to provide for the use and the consumption of cannabis and related products, the commercial cultivation, the sale of cannabis and related products, the use of cannabis and related products for medicinal purposes, as well as the expungement of criminal convictions related to the possession, the cultivation, the sale, and the use of cannabis and related products. And of course, we do support, Chair, the prohibition of the use of cannabis whilst driving, because, Chair, we are a nation which has about 14,000 persons dying every year on the roads. And many of these are because of substance abuse. We simply cannot afford to send more families home having lost loved ones. Chair, the areas of concern that we have as COSATU in the bill is that, so we support the bill in principle. We believe Parliament should pass it before the end of this Parliament, but we remain concerned about several provisions in the bill, including some of the new amendments. The bill appears in many instances to reflect a level of contradiction between different departments in government. So it seeks to legalize the use of cannabis, yet it places significant restrictions in that regard. On the issue of immature quantities, the bill places restrictions on the possession and sale of limited quantities of immature plants. And there appears to be little justification of this beyond perhaps a bureaucratic sullenness towards the legalization of cannabis. We're not sure. On the issue of accessible to children, so whilst the bill has various restrictions with regards to children, these are welcome. It is concerning that the revised bill has removed clause 3.2a, which requires the owner to ensure that cannabis is not accessible to children. We thought that was a clause which made sense, and it seems to have been removed from the revised bill. On the issue of religious and cultural activities, and we know this is a very difficult thing to manage for a variety of reasons, but the bill correctly seeks to provide for the legal use of cannabis for religious and cultural activities, yet it then places a raft of bureaucratic and often impractical conditions for this right to be exercised. So namely the requirement to apply for permission from the minister. One can imagine the minister is busy with many, many other things. The requirement for the minister to consult with other ministers and MECs and government institutions, where we know how ministers struggle to get hold of each other's colleagues on often many issues. The need for proof of registration as a religious or cultural body. One doubts that most of our religious institutions right now are registered. The need to indicate how many persons are members of such religious or cultural groups, and they need to indicate who will be part of the specific event. And we think that's going to be quite an administrative nightmare for these institutions and even for government itself. How would you verify and quantify who's a member, who's not a member? We think the effect of such excessive and we believe bureaucratic and daunting requirements will simply discourage the relevant religious and cultural bodies from seeking to comply with the law. And this is the exact opposite of what we want to achieve. The failure also to comply with the law will then place them at risk of being arrested, convictions and so forth. And this would really undermine the very purpose and intention of the bill, which is to legalize and to regulate cannabis. It also places our police officers in an unfair position of having to go and to inspect churches of whatever religion and to engage in this kind of thing. It's going to be a real nightmare for them to try to manage this kind of issue. Do we have a database, for example, of Rastafarians? We doubt it. So the practicality is going to be quite worrying. On the issue of penalties, so the bill's provided for reduced penalties for various offences, and this is welcome in principle. But we think, Chair, again, this contradicts the directive of the Constitutional Court, which is to legalise cannabis, and government's own efforts to nurture and to cultivate the hemp industry. So reducing a penalty from 6 to 3 years, for example, is welcome, but nonetheless, we do think it's still going to serve as a serious and a real discouragement for those seeking to legally enter the industry. So in conclusion, Chair, we welcome the bill in principle. We support its passage in principle, but we are quite concerned as COSATU that several key provisions contradict and undermine the Constitutional Court directive to legalize the sector, as well as some provisions that we believe will serve to frustrate those who legally seek to enter the commercial sector, and thus weaken government's efforts to grow a legal industry. We're also worried, Chair, that we are rapidly running out of time before the 6th Parliament concludes its work. So if time allows, and we're not sure how much time do we really have left, but if time allows for further revisions to address the weaknesses and the contradictions in the bill, then COSATU would urge the Portfolio Committee in Parliament to do so. But again, I think we need a bit of a frank and a brutal conversation, or honest conversation rather. If this window of opportunity is passed, Chair, to the parliamentary programme, and the passage of the bill itself will be placed at risk of not happening before the end of this Parliament, then COSATU would simply urge the Parliament to pass the bill. And then we would acknowledge, I think the bill itself also acknowledges that further supplementary legislation will be needed for the commercial cultivation of cannabis and related products. So I think, Chair, it's a difficult scenario, but having worked in the parliamentary sphere for some years, one appreciates that we are rapidly running out of time, basically until the end of November. No work will be done next year. We also have a 2.5-month recess now, and of course the committee would urge them to do some online work if needs be. But I think, Chair, we are quite worried that we might face a scenario where we don't get this bill passed by the end of this Parliament. That's not an idle fear, but we've seen in the previous Parliament where about 19 bills weren't passed because we simply ran out of time. So I think, Chair, we just wanted to highlight areas of concern that we still have, some contradictions we think are still significant, and to encourage members to see if we can address them. But if not, at least let's get this bill passed and move on. But I think, Chair, lastly, would mean the 7th Parliament would have to do, either way, would have to do some significant further work, we believe, going forward. But yeah, thanks very much, Chair, and hope we stuck to the timeframes. Thanks, members.
Thank you very much, Mr. Parks from COSATU. Members, that is the presentation from COSATU. Any questions or comments? I have Honorable Yako and Honorable Jele in that order.
Thank you so much, Chairperson. I don't know, Chair, you can call me out on this one. I just find that COSATU is forever coming and doing public submissions, and I'm not sure if perhaps they've got KPIs for sending in public submissions or what. However, Mr. Parks has just read back to us this bill. We know the concerns of this bill. We know that we need to pass this bill before the 7th Parliament. But I want to know, because he's not illustrating to me what COSATU's interest is in this bill. And he's not being succinct in his message as to what basically does COSATU want us as Parliament to highlight in this bill. I'm not hearing him, and I'm concerned that sometimes we do these processes and we do them because we perhaps, of course, we have to do them, but I'm worried about the caliber of submissions that we're receiving, because I mean I even prefer the previous submission because it was very honest from the Daka Party. It was very succinct. It was very, he knew what he was talking about. I'm not sure, Mr. Parks, if he even understands why is COSATU submitting? What is this submission? Because you're just reading the bill back to us, and I'm not hearing what the proper concern is. Yes, we're going to pass the bill. Yes, we want to pass the bill also. We don't want to leave any legacy in the 6th or 7th Parliament, in the 7th Parliament for our work that we've done this term. But can he just tell us what is the interest of COSATU in this bill? Just plainly. Thank you so much.
Thank you. Honorable Jele.
Thank you very much, Chair. And also let me just thank COSATU for also having this input, and also, Chair, also reminding us that, which we also know, that we need to pass this bill. Indeed, we have to, as part of our legacy for this term, the 6th Parliamentary session term. So, but Chair, I think what I'm going to say is let's also, I think there are some positives that they are also raising in terms of their concerns, that I feel that because the bill is still going to go to NCOP, meanwhile we are going on discussing and listening to these presentations, we must also look into those contradictions so that we make sure that we pass a bill which is in line with the constitutional requirement. if indeed there is something like that, the department will have to look into that one so that we move forward with a bill that will not be constitutionally challenged. That will be my comment for now, Chair. But just want to thank the COSATU for this presentation. Thank you very much.
Thank you, Honorable Jelle. Mr. Parks from COSATU.
Okay. No, thanks, Chair. So I think thanks to Honorable Jelle for listening to the concerns and so forth. It is a contradiction, Chair, because we appreciate the Portfolio Committee has done a significant amount of work on this bill. And I think the fact that the Portfolio Committee's had 3 rounds of public hearings on the different drafts and so forth shows you the level of commitment and the inclusivity that the approach the Portfolio Committee has taken. We wish that the Portfolio Committee would still see if they can try to address some of the concerns we've highlighted, and I'll just raise them again in a second. And yes, it is true that it will go to NCOP. The NCP public participation process, Chair, with the greatest respect for NCP, are not as inclusive as those for the national assemblies. They tend to delegate it to provincial hearings. They tend to just simply take it to a community hall and give members of the public, a minute or 2 minutes to raise their issues, but doesn't tend to be the same kind of in-depth level as the Portfolio Committee. So that's why it's more useful at times to have these engaged in the Portfolio Committee. The Chair, just to Honorable Yako. So I think, look, Chair, as COSATU, we don't want to really engage in any insults of the EFF. I think it's not really productive or useful. They can, be disparaging as always to COSATU, and that's fine. That's for party political purposes. So, Chair, we've stated, perhaps the member didn't have time to hear or to read our presentation, but we have stated that as COSATU, members are workers like anybody else in society, so they're not divorced from any other issue in society. Second is that we have members who are police officers, pop crew. They've complained frequently about having to go after people who are not really criminals because of some of the laws that the Constitutional Court has highlighted. They much would rather go after actual criminals. We've got health workers who would love to provide medicine which will help patients. And again, there's a need and there's an opportunity for hemp and so forth to provide that. We've got workers in Mercedes-Benz where the products can be used for building cars, etc., clothing workers and so forth. So that's the vantage point. Of course, COSATU members, like anybody else, has got a vested interest in what Parliament does. So, Chair, I think the fact that the Portfolio Committee has had 3 rounds of hearings on this bill shows you that there is issues with the bill. There are contradictions. I think the fact that many civil society organizations will attack the bill shows you there are challenges. So, Chair, the honourable member had just simply had the opportunity and time to have read our presentation or listened to our PowerPoint presentation. We have highlighted some of the contradictions. So yes, we support the bill in principle. We want to see it getting passed, etc., especially given the timeframes. But on the one hand, we're saying let's legalize this product. On the other hand, we're still providing for significant restrictions and also penalties. That's a contradiction. Chair, the previous draft of the bill had a clause saying we need to ensure that children do not have access to the products at home. That's been removed now, so that's a concern, Chair. There are contradictions around the issue of quantities. Are we legalizing it or not legalizing it? Chair, we've highlighted, for the benefit of honourable members, the contradictions around religion and cultural groups. So one of the major motivations for legalizing this product is that it's used for religious and cultural purposes. Yet we've put in place in the bill quite extensive clauses around it, but the practicalities of it, Chair, don't make sense. Chair, it's fine for Parliament to pass bills and they look nice in English on paper, but if we're going to be expecting that we're going to register every single religious institution, they're going to have a registry of all the members that they're going to be able to give to the minister, who then must consult other ministers and MECs and so forth about their activities. That I think we're being a little bit unrealistic about the practical implementation of those things. We should have a much more simple process to make the use for religious purposes fairly easy. And again, Chair, if we're going to have such a difficult, extensive clause on religious and cultural groups, we're then shifting a very unfair burden to police officers who are now going to have to go to these churches, religious activities, cultural activities, and then ask them provide us your membership, provide us your registration papers, etc. That's going to create an unnecessary conflict, and that really does undermine the directive of the Constitutional Court, and of course the progressive spirit of this bill as well. So I think that is in essence our issues, Chair. But I think we do want to appreciate the very inclusive approach members have taken around this bill. And we had raised lastly, Chair, the issue of the timeframe for Parliament. And one might say that, well, COSATU is just being silly as always, that's fine. But Chair, we're speaking from practical experiences. We have been around at Parliament for quite some time. And we've seen the last Parliament, I think as honourable members would know, the Chair, Honourable Swart, many other members here, that Parliament does run out of time. We would not want to see this Parliament running out of time to pass this bill. And it is already going to be quite a steep exercise for the NCP to get done before they rise at the end of November. But Chair, we hope our submission, the issue we have raised around the legal contradictions, the issue of children, of quantities of religious and cultural groups, etc., will assist the members. And thanks once again to the members for giving COSATU some space to make our submission and so forth. Thanks, Chair.
Thank you very much, COSATU, for your contribution. We will look at the issues you have raised, and we are trying by all means necessary to ensure that we pass this bill, and we pass it in time for the NCOP to also have time to interact with the bill. So we will do whatever we can to ensure that whilst we are not bending any rules, we are following all the rules as we have demonstrated. There were, in some instances, we had to, when we are about to conclude, then certain procedural aspect will come out that would need for further public comments and further engagement with other stakeholders, including, lastly, it was the House of Traditional Leaders. We did that, but we are really, as you have raised it, Mr. Parks, we also concerned that we are running out of time, but we will ensure that we do whatever we can to ensure that we meet the deadlines. Thank you very much, COSATU, Mr. Matthew Parks. Doctors for Life? I don't think they are. If they are, can I call them again? Are they on the platform, Doctors for Life? Can we move to the next presentation, Cannabis Trade Association? No, sorry, Cannabis Trade Association Africa.
Yes, Chair, we are ready. Can we please share the screen?
Okay. Mr. Tsopane, you are welcome. Thank you for responding to the call to make public comments. The time is yours.
Thank you, Chair. Good morning, everyone, and thank you again for giving us the opportunity as the Cannabis Trade Association to submit. It's our second time doing a submission, and we hope that we can be able to be as fruitful as it can be with regards to this is concerned. I'm just trying to get this thing to work as a presentation. Okay. I think it's fine. So, Chair, the technology is failing. Slideshow. Sorry, Chair, can everybody see this screen?
Yes, yes, we can.
Fantastic. On a general framework, CTA...
Sorry, Chair, Honourable Neodruchen, can you press there where you pressed on slideshow?
Okay.
There on slideshow, and then you say play from start.
Slideshow.
On your left-hand corner.
Left-hand corner. I'm just having the screen here.
Well, it says play from start.
Hang on, play from start. Can you see it?
No, it's not on slideshow. If you press slideshow, then there's a pop-up that comes and it says,
Sure.
yes.
Play from start. There we go.
Go.
Got it.
Here we go. Better.
Okay.
Thanks.
Thank you. Thank you. All right. Been trying to read this at the same time. Okay. CTA recognized the voice of Jeremy Apton and Gareth Prince, who's going to be speaking also, I think, tomorrow or later on after us. We also recognize the need to have a broad cannabis bill to ensure that we capitalize on all the opportunities cannabis offers individually or to individuals, companies, and the greater South African public. CTA prefers that cannabis reform be consolidated in a single regulatory framework. In other words, a single piece of legislation regulating cannabis, and is preferable to the fragmented regulations that we have currently. CTA will be commenting on these areas around the addressing the facility creations of cannabis industry as well, and mostly for trade, because at the end of the day, as CTA, we are for trade, Chair. The point that we're going to raise is on this slide is the awareness of certain questions, make sure that, the narrative to ensure that we open trade as cannabis for all South Africans. CTA is not against regulations, but we are for fair and reasonable regulation, Chair. On the context, there's been a 0 death attributed to cannabis globally. And the World Health Organization has declared that CBD should be unregulated and is one of the safest products ever tested. South Africa has a huge traditional cannabis growing traditions and a user market as well. I mean, there's been cases of reports that have come out in terms of how much cannabis actually is used in South Africa. The South African Health Regulatory Council Association, SAPRA, has been tasked to keep safe the public with regards of South Africa with the potential harmful medicines through the use of regulations. Now, the reason we mention is because cannabis is not in that realm of harmfulness as we then depicted. And why are we here? CTA and other previously we've raised concerns and comments in the second round where we clearly not taken into account and not reflected at all in the current draft. And the question is, why are we taking this seriously at all in terms of how do we create a legislation that can actually benefit everybody else? The problem with the bill as we stand is that it has limited the proposed bill limiting growing for personal use to a 4-plant rounds counter to the Constitutional Court ruling and undermines the right to privacy. In other words, how are you going to police that? The resources that you're going to use to police that. An individual wishing to cultivate more than 4 plants would automatically have a criminal record in a sense. And the bill contradicts with the Constitutional Court ruling that guarantees the right to privacy for personal use and growing of cannabis. The fear is that the police will have the power to come to people's homes and count plants, which at the end of the day would not be practically possible to do it. And it's going to put undue burden in the police resources if the bill stands as it is. And that will obviously be a clear violation of individual rights, privacy, and autonomy. Now, actions to be taken. Let's seize all petty cannabis arrests and prosecutions, i.e. the exemptions of those related to large-scale illegal dealing. So we're not talking about massive drug trafficking here. We're saying that if some of these arrests are petty arrests that that have been taken by the police, and I think it's important that we should stop all those things so that we actually have at least a voice that says that it's not a criminal offense. Suitable amendment of definition of cannabis. We should do away with reference that says that insofar as a large-scale illegal dealing is concerned, to allow that we have a legal trade of cannabis and or hemp. suitable amendment with limited flow through references to the Medicines and Related Substance Act of 101 of 1965, to include references, among others, the Plant Improvement Act 53 of 1976 and the Traditional Health Practice Act 22 of 2007. Its further exemptions to the presentation to present the prohibitions of dealing in cannabis. What is correct? We do wish to applaud the introduction of the section of the commercial activities regarding cannabis. We eagerly await the opportunity to make submissions and proposal in how this commercial regulation framework should be structured. In regards to that, we refer to the final report of conceptualization and motivation in the key provisions of enabling regulatory framework for cannabis, compiled by Weber Wenzel in 2022. We are happy to share that at your request. We also thank you for the allocation of governance and oversight of hemp, particularly, to be removed and be placed within the Department of Agriculture. And we support those allocations of powers. If we dive deeper into the bill, the definition of cannabis and hemp, to distinguish cannabis from hemp as defined, this is placing considerable burden on individuals to have in-depth knowledge of cannabis cultivars, in a sense that how do you differentiate between hemp classification? In a case, and some of these situations where South Africa has its own cultivars, South Africa has its own land-raised strains, which are, when you look at the THC, it's not as high. So if we can use those and say classification to be hemp, that will also open up a huge opportunity for us to be able to cultivate this particular hemp where it's been cultivated as we speak, Emampon and various other places around the country. It is in our view that law enforcement officials should not be burdened with enforcing the regulations of growing and possessions of plant, but instead police the legitimate and illegitimate use in which the plant may be put in, meaning that police the activity as opposed to the plant itself. We do not support the principle of presumptions of illicit activity within the context of cannabis cultivation or possession. Criminalizing the behavior of someone who cultivates or possesses more than a prescribed quantity of cannabis, especially as it relates to private space, the setting prescribed limits on cultivation and possessions of cannabis is arbitrary. If one considers the many legitimate use of cannabis, which requires supply of more than a proposed prescribed quantities, we submit that it would be more constitutionally feasible and more rational to oblige investigators, prosecutors, prove actual illicit dealing in cannabis. In other words, policing the actions and activities of individuals. The prescribed quantities. As a result, with curious results of classifying adult cultivating to 4 flowering cannabis plant in law-abiding citizens exercising his or her constitutional rights and freedom, and in adults cultivation of 6 flowering cannabis plants as an offense, as offender trafficking cannabis, meaning that you are turning people into criminals by just making these limitations in place. Underlying the rationale of, and it's unclear.
2 minutes.
Thank you, sir. Limitations is no doubt vulnerable, and I'll just move on quickly to some of the things that we want to see happening. I think in a nutshell, Chair, what we are trying to say in this case is that we would prefer that we don't have these limitations of 4 plants, because individuals may want to use hemp or cannabis for whatever reason. Someone may actually cultivate it to produce biodiesel, or cultivate it to build their own homes in terms of hempcrete and all sorts of things. So we need to have provisions for things like special committees and clubs. In this case, we don't have that. And it will allow that people who don't have private spaces to be able to grow cannabis with other friends and people that they share the same interest, and share that within a club form. So if the club model can be actually be incorporated within this bill, it will be a much more fairer bill to work with. And in recommendation in terms of usages, we should aim to stay away from governing cultivation, as we emphasize, let's not govern the plant, but the uses of the plant. Thank you so much.
Mr. Topane, members, are there any questions? Honorable Yako.
Thank you so much, Chair. It's not really a question as much as it's just a comment as to basically what I was saying. This is what we're looking for in terms of what submissions should be. Because I do take into cognizance the issues raised by Mr. Klapane, especially with regards to how the policing of this bill would then be infringing on private, our personal space, basically. So I think, I think we do take the submissions and they're very clear. And I think maybe as we go through the bill, we may see how we can, assist in terms of the concerns that this organization has. Thank you so much, Chair.
Thank you, Roman.
Thank you very much. Is there any member who would want to make comments or ask questions? None. Mr. Willie Sealing, I assume you're not a member, is that correct?
I'm not a member, but I'm a doctor. I need to comment about something, if I may.
No, please. It's for members interacting with organizations that have asked to make presentations. So if you are part of those who will be making presentation, your time will come. If you are not, this is not a process. Thank you very much. Can we go to the next presentation? National Nyambimbi Council of South Africa. I take it, Mr. Klapane, that you have no comment.
No, Chair. As far as this is concerned, we have no further comments. Thank you.
Thank you very much. Thank you for taking the time to input in this particular process. We value all the inputs and we will respond accordingly.
Thank you, Chair.
Thank you very much. National Nyambimbi Council of South Africa. Are they on the platform?
Oh, Chair, there was here just a moment ago, but they're absent right now.
So they're not on the platform now?
No, sir.
Thank you very much. Let's go to the next one. Is Mr. Paul Michael Keisha?
Greetings to you, Chair, honourable members of Parliament and the various members of civil society who we are serving in this process. I hope that everybody can hear me and see me.
We can see you and we can hear you clearly.
Wonderful, thank you.
You have 10 minutes.
Thank you. Just to point out, there seems to be an enduring confusion in that the Constitutional Court did not mandate Parliament to implement legislation for full legalization. So just to the extent that the bill does go beyond regulating personal and private cultivation and use of cannabis, this is clearly Parliament exercising its prerogative. And I suspect that this is in an attempt to meet what the Honourable President Ramaphosa promised us in at least his two last State of the Nation addresses. Now, everything that I say here is with the greatest of respect, and I hope that I'm not later accused of perhaps overstepping a boundary. It certainly isn't intentional. But I would like to say, again, with respect, that it has been artificial to confine us to addressing this portfolio committee on only the commercialization of hemp plug-in, because the question will throughout always be begged as to whether this foundation is sound enough to be built on, the foundation that is the rest of the bill. Now, I say this because Section 36 of the Constitution, the supreme law of the Republic, requires that the state, not civil society the other way around, but the state has to justify rights limitations. And this is with reference to considerations such as the purpose of that limitation, whether that purpose is achieved, and ultimately whether there are less restrictive means to achieve that same purpose. Now, certainly there's going to be submissions to you throughout these 2 days that there are certainly less restrictive means, and that is, for that matter, recognized in the National Drug Master Plan 2019 to 2024, which says that the medicinal and social services of government ought to intervene to minimize the the harms of drugs. And this ought not to remain a concern of the criminal justice system unless in the most extreme of circumstances. That said, we can see that matters such as hemp, commercialization of cannabis, and cultural accommodation seem to be capitulations by the Honourable Committee, but they are unprecedented statements of intention and do not, with respect, belong in legislation. We do not get it right, then this will be tied up in court for many years to come. And that would achieve the opposite of what COSATU wants, which is to pass this through and get a regulated trade and system in relation to cannabis. So again, we have to ask ourselves, why not use the opportunity to get this right now with specific reference to sections 1 or to section 1A of the Constitution, which talks about the fact that we should be promoting human rights and freedoms, not rushing to limit them. The only rush really is for the South African police services to cease arresting people for what are already no longer crimes in terms of the judgment of the Constitutional Court. If that could happen, if there was an order by the executive or the such, or a memorandum that went out to the South African police services, the likes of which we've seen before, we could achieve that, and it would give everybody the breathing space to get this right the first time round. Having said that, I will confine myself to the hemp plugin after this, given that as a lawyer, I remain a creature of instruction. I will just make a comment in relation to what was discussed at the beginning, Doctors for Life, an organization that is self-proclaimed to be quite conservative. They got in the way during the Constitutional Court case or during the court case in 2017. And the perception now amongst many members of civil society is that they're doing so now again. So that said, I'll just plug in a caution here that their comments need to be entirely disregarded to the extent that they are attempts to claw back on any relaxations on our rights that were already granted to us by the Constitutional Court. It does not, with respect to them, seem that they have respect for foundational laws such as sections 1, 2, and 36 of our Constitution. Having said that, over to hemp. We are always going to find ourselves in difficulty if we try to divide one single plant into different categories with reference to things such as THC. Now, I'm going to ask 3 rhetorical questions. How do we enforce this against the rural Amapondo who want to grow adult use cannabis and then use the stalks for hempcrete to build their own private residences? Are we going to force those rural Amapondo to switch their landrace cannabis for imported hemp cultivars if they want to dabble in the commercial hemp space? And what are we going to do about an issue such as cross-pollination? Will the rural Amapondo find themselves a criminal and forced to destroy their hemp crop because of cross-pollination from someone else's adult use crop 1 or 2 valleys over? Another rhetorical question. And it stems directly from the hemp plugin. How does the state intend to differentiate between cannabis plant cultivation material and hemp cultivation material for purposes of private use? Must civilians confine themselves to growing only approved cultivars and only below a certain number and level of THC if they intend to grow a hemp hedge around their property or to cultivate sufficient herd to build themselves a hempcrete kraal for their cattle? I'm going to end there, but I'm going to say that in summary, and with respect, this bill is disjointed, it's unconstitutional, and it will ultimately prove unenforceable. I do not think that we're going to achieve anything by fixing it piecemeal. With respect, I think the solution is to start again on this bill. And I qualify that by saying that unless it goes back to the confines of what the judgment of the Constitutional Court wanted of us, which was to limit this bill to regulating the personal, private cultivation and use of cannabis. Thank you.
Thank you very much, Mr. Kachel. Any questions, members? Honorable Jala.
Thank you very much, Chair. I'm not sure whether it's just a comment. The presenters they come from different angles in resolving the issue of the constitutional imperative, Chair, when it comes to making sure that this bill meet the requirement. And the view that we can even attempt to start afresh with this bill, I really don't think it is really making sense or possible, because of the work that has been done so far. And also, Chair, the issues that they are raising, we are still going to talk about them, but I don't even want to promise that it will start afresh when we go and deliberate on this matter. I wanted just to comment on that one. We are really noting the concerns and the views around making sure that this bill is according to the prescript of the constitutional law. But I wanted to raise that issue of saying starting afresh, I don't think it will be possible. Thank you, Chair.
Thank you, Honorable Jale. Mr. Kishan.
Thank you. If I can just comment on that. Look, starting afresh is perhaps it's an exaggeration. What I mean to say is to go back to the drawing board in respect of what this bill is supposed to be. But in response to the work that has already been done, and I do respect that there has been a significant amount of work and many hours, if not days and weeks, spent on this. Unfortunately, one mustn't fall into the sunk cost fallacy. The bill, if it is going to get tied in court for a number of years because it is unconstitutional, would not achieve the purpose and would then render wasteful the significant time that has been spent on the bill. So it's really just a caution to say, well, let's get this right now, whether it is starting from scratch or whether it's panel beating it to be to rather be constitutional. Ultimately, the end product needs to be constitutional if it's not going to get tied up in court for a number of years, and that's really what I mean to say by that.
Thank you very much, Mr. Kishan.
Before you go, with due respect, Chair, I wanted to find out about this issue of bringing the police into the whole picture. The presenter, exactly what is he saying? That, in fact, not him alone, because even the other ones, the other presenters were raising concerns in terms of the police having to enforcing the law, going to the houses in terms of making sure that there's compliance. My something that I really don't get it clear is, Chair, I wanted to find out, are they, the presenters, saying this should not be it should not have restrictions in terms of the quantity, yes, in respect of the quantity, it should be just left into everybody doing as they wish, planting as many as they want and using is the way they want it. Is that the impression that they are trying to advocate for, Chair? Just want to find clarity on that one. Thank you, Chair.
Thank you very much. Mr. Kishan.
Thank you for the question. The role of SAPS is a multi-pronged approach. So let me answer it in at least two prongs. The first is that the Constitutional Court declared in 2018 that to personally and privately cultivate and possess and consume cannabis was no longer a crime in South Africa. Yet there are certain rogue elements within the South African Police Service who continue to arrest members of civil society on a daily basis, expose them to trauma, ruin their lives, shake them down for bribes. The information is there. One of the following speakers will be Myrtle Clark of Fields of Green, and she can speak to you more fully and comprehensively about this. The second element, yes, indeed comes down to plant counting. At the moment, nobody purports to have any authority to come into your house to count the number of bottles of whiskey that you have in your cellar, or the number of cartons of tobacco that you have stored for your personal and private use. That is because it would be an unconstitutional invasion of your right to privacy to do so. How can a police officer come onto your property and start counting your plants absent an arrest warrant or a warrant to search? But it's a little bit more fundamental than that, because what we're saying is that like cases need to be treated as alike, because if you are going to put a limit on the number of plants that somebody needs to be or can lawfully be in possession of, then you need to be very clear about the harm that you are preventing by putting the lawful or the legitimate harm that you are preventing by purporting to put a number or a cap on the number of plants that somebody may have. Because otherwise it may be that you're inadvertently exposing people to more harm than you are actually preventing. For example, by having their doors kicked down and having their homes searched by the South African Police Services. So ultimately it is a matter of degree, and it's a matter of equality, because if you don't do these things in respect of the users of alcohol and tobacco, then you ought not to be doing these things in respect of the users of cannabis. I hope that does answer your question.
Thank you very much, Mr. Cashel. Thank you for taking the time to make this contribution. We don't take that lightly. All the views are going to be taken into account when we deal with the responses and deliberations. Can we go to Chief? Let me check here. The Chief Zweli Kanyele of the Magema Community Trust.
Yes, sir. Yes, sir.
You are welcome, Chief. How are you?
Thanks very much. I'm okay, and how are you?
Thank you very much. You can proceed.
Thank you, Mr. Chair, for giving me this opportunity to be part of this meeting. Greeting to you, Honorable Chair, together with honorable members. I'm Chief Hugo Zweli Kanyele from Eastern Cape in St. John's, Magema Administrative Area in Bondoland. I'm the founder of Magema Community Trust. It's my first time, sir. It's my first time, Chair, to present like this. I used to be there in a great place together with elders to solve issues of the community. So I hope it's not the last time to be part of this meeting. Mr. Chair, when we are talking about cannabis, I feel so deep. There's a lot of memories that comes in my mind. I remember the time where still boys growing up, we used to mix the inner core of the cannabis tree together with mud to make those car, because we from far from town in St. John's, but deep down in rural areas. So we used to make these cars as toys because we don't have access to go to town. Mr. Chair, we feel isolated as rural areas. We're facing many social and financial difficulties. As a community cultivated the land race cannabis for more than 150 years, 100,000 hectares of industrial and 1,000 small-scale land race farmers. Ask to do slides. Mr. Chair?
Yes, we can hear you, Chief.
Can you do slides?
Committee Secretary, can you assist with slides?
Yes, greetings, Chair. Yes, you can present, you can project, Chief. Thank you.
Okay. Okay. Mr. Chair, are you there?
Yes, we can hear you.
Okay, thank you very much, Mr. Chair. Mr. Chair, we've been building a modern for the last 5 years in the hope of government implementing issue to unlock economic value of land race. I've been working with the community together with elders and advisors and also private industrial stakeholders to leave a legacy for generation to come. Pilot to deeper rural industrial cannabis decoditors and agro-processing hub to create wealth for our community from our cannabis as an agricultural and industrial commodity. Our community unlocking and owning the full value chain of the cannabis plant by building a world-class industrial cannabis manufacturing business. China has dominated the global hemp fiber market. The global project to be worth $26.41 billion in 2026. South Africa agreements, if regulations permitted the inclusion of land-raised cannabis and land-raised cannabis farmers, have industrial hemp fiber production opportunity to dominate the global market. What I believe is that beside, Mr. Chair, to import a lot of things, we can do things by ourselves, especially down there in our rural areas. I believe that we can do that. The generations of South Africa rural economy, assisting South Africa to achieve the United Nations Social Development Goals, UN SDGs. Making community trust seek to maximum the application of the industrial capabilities of our local land-raised cannabis. We intend to utilize the whole plant approach to agro-processing, pioneering the stimulation of rural economies with a focus of indigenous farming and industrialization, together with other communities and similar projects in the Greater Pondoland areas, creating social economic upliftment, development, and transformation opportunities for our rural areas. Mr. Chair, we are not just us as a community of Amagin, as the Pondo people from different villages. We used to have a meetings down there in Pondolands, us as traditional leaders, together with other stakeholders, to discuss what we can do to grow our communities by using this cannabis. Sorry. And then okay. Sorry. Okay. Falls short of enabling, empowering, and upliftment the massive benefit that are posed for the industrial application of thousands of hectares of local grown, environmental, and genetic suited, drought and fungal tolerance land-raised cannabis sativa. Why the need of regulating industrial cannabis? Land-raised cannabis sativa should be included as approved cultivar, or that a certain exemption elements be considered for our traditional farmed land race. Why do we aim to regulate an agricultural commodity at the farmer level and not at processing level? We recommended and industrial cannabis be defined and regulated by the industrial use as textiles, building material, natural health food, and not mainly on THC levels. For generations, land-raised cannabis growing community have been marginalized, persecuted, and abused due to oppressive legislative parliament. Now have the opportunity to bring about transformation to move towards correcting the injustice of the past. I remember, Mr. Chair, 7 years ago, there was a helicopter that came to us and spray our ganja together with our vegetables. Everything was damaged. And then people used to be beaten by the police, especially they just came and then take everything and then beat us. But now we believe that we need the freedom just to move forward, because we can't repair the pain, but what is important is to move forward with a life. That's what we are asking. We request the parliament to consider legislation that focuses on rural regeneration, including existing traditional farmers in the value chain without the red tape, maximizing our competitive advancing with resilient genetics, avoiding further barriers to participate in the economy. We have submitted that the implement of efficient and inclusion legislation and regulation will prevent potential legal challenges, especially where impoverished traditional communities do not have the means to do so. Makengu Community Trust supported the UN SDGs. We all the 17 partnership for the goals. So I thank you, Mr. Chair.
Thank you very much, Chief. Members, any questions? Honorable Chair.
Thank you, Chair. Let me just say, Siamuzo Uchi, we hear him, and we will sit down. Yeah, we will continually refining this bill together with the department. We note the presentation. Thank you, Chair.
Thank you very much, Mamujele. We thank you very much, Chief Zulikaya. Sibulela ukuthi uthathele ithuba wenze i-contribution yakho together with that of the organization. But there is also another hand of Honorable Janji.
Lord Chair, for raising it late. I've been put on the clarity apha ku-Chief Diko.
Yes, sir.
Uthi ne-Chief Diko ndifuna ndiphoselele ndawo uthi wawusenza into zodlala ngodongwe nentsango okanye uzenza ngentsango qha ezaa memories zakho ubuthetha ngazo apha. Ndihamba jasu ukhawuye wakhawuleza udlula apha bendizamamele kakuhle uba kudala ukule nto. Nkosi Chair.
Okay, thank you, sir. When we are growing up as boys in Mhlekazi wami, we used to mix inakho ukhona umphakathi lona umthi lona wecuba. Ikhona into engathi umongo wecuba pha stem say inakho, and then ukhupha yona and then we mix it with the mud. Ukwazi ukwenza ezamoto strong zodongwe, those cars. Even if you want ukhona abaronda vele bapha emakhaya ukuba ufuna ukutyabeka pha to make those ronda very strong, umixa la inakho with mud, uyenza nokuyomelele noba these heavy rains, so they can't just penetrate easily. So bendibeka ngolo hlobo ke ngokumhlekazi wami ukuzenza zingakuziba zikwazi ukuchachamba zingabina cracks those cars, and then we mix that inakho together with mud.
Nkosi Chair. Thank you. Nkosi Chief.
Okay, Nkosi Mhlekazi.
Thank you very much. No, siyabulela kakhulu Nkosi.
Nkosi.
Thank you very much. The National Nyambimbi Council of South Africa has rejoined. It is part of us now. Can they proceed? National Nyambimbi Council of South Africa.
Hello, greetings.
Greetings.
Can you hear me, Chair?
Yes, we can hear you. Proceed.
Okay, thank you very much. I didn't realize my mic was muted and I was speaking. Greetings to everyone, all protocol observed. I'm not sure if you can see me. I can't see myself on this video here.
We can see you.
Okay, thank you very much. I will start on the second slide. Please go to the second slide for me. Introduction. The Nyambimbi order has responded to all calls for public submission with the belief that our comments will be considered as cannabis is in the center of Rastafari way of life, and we have a right to self-determine our future. The Nyambimbi order notes, for the Rastafari community, the Nyambimbi, which is the Church of Rastafari, submission must be considered along other inputs from Rastafari individuals mentioned organizations that submitted. Past submissions indicated the Rastafari community generally rejected the bill as it stands. Rastafari advocated for the total liberation of the plant. Our presentation is as follows. Comments on hemp, comments on cultural and religious use, other past comments not considered, and conclusion. Next slide. Are you still with me, Chair?
Yes.
Comments on commercialization of hemp. The Nyambimbi order submits. Generally, we reject hemp as an exotic genetically modified plant. We submit that law must recognize that originally hemp existed in the form of the low THC cannabis, male species. And further, hemp was not a plant, but was the industrial use of cannabis stalks and seed. Number two, approved cultivars. We refuse to be colonized by regulation that we must use registered seed from registered suppliers, which means importing cannabis seed. We submit that Rastafari farmers must be allowed to plant low THC indigenous dacha, which we call local hemp. Indigenous seeds will result in higher yields and financial viability for farmers. Number three, percentage of THC. We reject the less than 0.2% THC limit. We submit that the THC percentage limit specified for hemp must take into consideration the Southern Hemisphere and emulate other countries which have made hemp THC percentage limit between 1% and 5%, which are not psychedelic. Number four, destruction of hemp crops. We reject regulation that destroys hemp or any other cannabis plants. We submit that hemp crops or any other cannabis crops that exceed stipulated THC percentage must be converted into biofuels, bioplastics, biohousing, and animal feed applications for the benefit of the poor communities. Fines and imprisonment. 5, we reject large fines, heavy penalties, and imprisonment proposed. We submit that planting hemp or any cannabis crops is not a crime, and any non-compliance must be treated like traffic violation fines. Number 6, medical applications of hemp. We reject a regulation that limits hemp farmers to seed and stock when the financial viability lies with the hemp flowers. We submit that hemp farmers must be allowed low THC flower and sell it to those who want it for medical applications. Number 7, permit conditions. We reject restrictive conditions like the size of land to be cultivated, expensive fence specifications, unnecessary police clearance, and non-transferability of the permit. We submit that hemp permit conditions must not create high barriers of entry for farmers from disadvantaged communities. Next slide. The Nyambimbi order reiterates some of our previous comments that were not considered in the latest bill draft as follows. There must be provisions on cannabis sacramental rights, as well as cannabis for industrial, medical, and private use purposes. There must be protection of Rastafari children who live in households that consume cannabis freely, similar to protection afforded to Hindu children consuming cannabis during Lord Shiva's birthday celebrations. Rastafari Nation must be empowered to self-regulate Rastafari cannabis sacrament permits or licenses, similar to rights afforded to Christian, Hindus, Jews in handling their holy sacrament or equivalent. Definition of private space to include Rastafari places of worship and public reggae cultural events. The Rastafari unique ITAL standard must be protected, similar to protection afforded to halal and kosher standard. Next slide. The Nabingi order has raised the following inputs to be considered. The rescheduling of cannabis as an agricultural crop and not a drug. Moratorium on cannabis arrest, immediate release of all cannabis detainees, and the expunging of all cannabis criminal records. Review limits on quantities to be stored and to be transported. Access to land for the historically disadvantaged communities. Provisions to set aside dispensary permits for traditional cannabis distributors who exist under the rider running as informal businesses. Enable exchange of rare skills and indigenous technology from other Rastafari in the diaspora. Provisions to protect the IKS rights to share in the commercial benefits of the cannabis plant. Cater for cannabis cultivation must be totally legalized and only cannabis commercialization be regulated. Customs and trade barriers to discourage imports dominating local cannabis. Enforcing BBBEE policy in cannabis industry. And next slide, conclusion. The Nabingi order welcomed the effort to decriminalize cannabis and to cater for cultural and religious purposes. However, we highlight the following. We ask that the bill does not use the term Rastafarians when referring to our community, but rather use the term Rastafari. As concerned and affected cannabis community, the Nabingi order continues to respond to all the calls that have been made around all aspects of the cannabis legislations. Albeit you have grave concern that our submissions are not considered, Chair. The Nabingi order strongly recommends further public consultation, which is meaningful and must not be used merely for compliance's sake. We therefore envisage an extensive consultation process that will inform and engage the community. Parliament must go to the people and would like to reiterate that there can be nothing for us without us. Our concerns are not just for the Rastafari community, but for all indigenous communities that are affected and that have IKS rights to cannabis. In KZN, we have met with King Misuzulu Isilo Samabandla and traditional authority kings who view cannabis as a means for rural economic development. Give thanks, Chair. I think I've done all my presentation.
Thank you very much for the presentation. Members, that is the presentation from the National Nabingi Council of South Africa. Any questions?
Right.
Any questions or comments? It seems to be clear. Honorable Nevot Truchen.
Apologies, Chair. Good morning to everyone. Chair, I didn't say, but those who are presenting those presenters who have slideshows, can they please be forwarded to the secretary so the members can have access to them, because sometimes it's much easier to read the presentations than the full submission. So if I can just request everyone to send their PowerPoint presentations to the Secretariat. Thank you, Chair.
Thank you very much, Honorable Chela.
Thank you, Chair. It's only one clarity question from the presenter, Chair, because I hear him saying, in fact, at the end of the presentation, he was just kind of saying, we need to go back to the people about this thing of like public participation. I'm not sure he will clarify me, because one question that comes into my mind is that, was he not aware that there were public participation sessions that we conducted earlier than this one? Because to me, it comes as if maybe to him, it's like we didn't go to the people and get their views in terms of this. Thank you, Chair.
Thank you.
Thank you for the question. But to be honest, ma'am, we have not been properly consulted. Only those who have emails. Most of our community was not consulted, and our views were not considered. So that's why we still put this to you, Chair. And we feel that not enough was done to consult the public, especially in their language, so they will understand what's going on.
Thank you very much, National Council.
Just a small follow-up.
And also, sorry, ma'am, traditional leaders were not consulted. For one, I come from a traditional royal house from Wandelu. Our traditional leaders were not properly consulted. They are not sure, and that's a fact.
I submit, Chair. I'm fine. Thank you, Chair.
I think let's move from this one.
Yes, Chair. Yes, thank you.
Thank you. Thank you very much, National Nyabingi Council of South Africa. Thank you for your comments. Let's move to Umzimvubu Farmer Support Network.
Good morning, Honourable Chairperson and Honourable members of the Portfolio Committee. My name is Ricky Stone, and I'm addressing you in my capacity as a director of the Umzimvubu Farmer Support Network. Unfortunately, due to the short notice in which these public hearings were called for oral representations, I was unable to ensure that my other team members in deep rural Pondoland were able to join and make submissions today. I do, however, make submissions on their behalf and indeed on behalf of the 100,000 plus rural indigenous cannabis farmers of the Amapondo region, specifically those that reside in the Tabankulu region and specifically under the traditional authority of Chief Lutando Dinwayo. Thank you very much, though, Chair, for this opportunity to make further oral submissions to the Portfolio Committee. We do note that you've requested that we limit our comments to the hemp clauses. We also do note that other presenters that have come before have extended their submissions to other aspects of the bill. We take no issue with that, Chair. Clearly, these are very emotive and sensitive issues, which are very important to all those members of the cannabis community. We will, however, heed your request. But with that said, we do not waive our previous comments in respect of the other clauses, which we do maintain remain unconstitutional. Chair, I think it's important to realize that the Umzimvubu Farmer Support Network was specifically formed 7 years ago in response to what Chief Diko from the Maklinki community and traditional authority raised in respect of this government's aerial eradication program of the Amapondo cannabis. So the Umzimvubu Farm Support Network was formed to provide support to those farmers who had suffered for 20 years this government's program spraying cannabis or glyphosate on cannabis. We were successful with that legal intervention and strategy, and we now serve the purpose of making sure that we can bridge the gap between the poorest of our poor in rural Pondoland and this government. And indeed, we engage with local government, provincial government, and as we are here today, engaging at the national level. Unfortunately, Chair, it does seem that our previous submissions, specifically in respect of hemp, were not taken into account, because with respect, Chair, had they been taken into account, this bill wouldn't factually refer to hemp, because quite clearly the heading itself speaks to say that it's only intended to regulate the personal and private use and cultivation of cannabis, not the commercialization of hemp. So whilst we do welcome the insertion of these hemp provisions, we do submit that they are misaligned. And perhaps what is very important, and the Portfolio Committee will appreciate, that the intention of the legislator is critical when drafting legislation and interpreting it once it's eventually enacted. And it's clear to me from a consideration of the minutes of the sitting of this committee on 23 November 2022, that amongst the members themselves, there is much uncertainty as to why these hemp provisions have now been included in a cannabis for private purposes bill. Members were specifically asking whether there is not redundancy and unnecessary reference to hemp, bearing in mind the amendments that have already been made to the Plant Improvement Act. Members also wanted to understand what the linkage between the bill and the Plant Improvement Act was. We would have then expected, Chair, that before this bill went out to civil society for broader comment, that it would have been accompanied by a briefing note from the State Law Advisor to explain exactly what the intention of the legislator is to now include these hemp provisions in this cannabis for private purposes bill. That would have been, with respect, the appropriate way to deal with it. So, Chair, if I can then go on and still confining my submissions to hemp, the Amapondo farmers, as Chief Deco rightly indicated, have used cannabis for hundreds of years, not only for spiritual, cultural, and adult use purposes, medicinal purposes, traditional medicine purposes. They've used it for industrial purposes, which is exactly what hemp refers to. Hemp is not a different plant. It is the same cannabis plant, Tsango, Dacha, Umia. And they use it for industrial purposes. Chief mentioned how they would use it to make their cars. They would use it to reinforce the building of their rondavels. So it's quite clear, and it's fundamental that the Portfolio Committee understands and accepts this, that the Amapondo indigenous cannabis farmers already use their indigenous landrace cannabis for industrial purposes. Now, Chair, with all respect, these additions of these hemp provisions seem to be a cure-all to try and cure the defects that already exist in the Plant Improvements Act. So on that basis, we will submit that they are entirely inappropriate. But one thing, Chair, and noting members of comments from some of the members that there is this rush, and specifically Kusatu's comments too, that there is this rush to pass this this bill within the next sitting. Chair, I would say, particularly in light of the most recent State of the Nation address by our Honourable President Ramaphosa, that we shouldn't be rushing anything. The deadline of the Constitutional Court has already passed. To avoid this bill being enacted and ending up being litigated for many years to come, because it is potentially still unconstitutional and hasn't been drafted with a human rights lens and framework in place, it is certainly not going to enable what President Ramaphosa publicly stated, is that he's shortly going to be actioning, and I understand that it has already been actioned, a process to put in place what the President called a whole plant, all legitimate purposes framework. So this bill, Chair, quite obviously is not that framework. Indeed, this bill is going to do more harm than good, and it does remain unconstitutional in too many respects. And with all due respect, Chair, this bill does take us one step forward, which is towards a regulated cannabis industry, yet 1,000 steps backwards at the same time. And to perhaps lean on the logo that Chief Deco from Magdenti community had on his presentation for his community trust, he uses the word "siya phambili," which means forward ever, backward never. But with respect, we are going backwards and we are not going forwards to the place where cannabis can be liberated for all legitimate purposes. Now, I made mention that the insertion of this hemp clause is inconsistent with what is already legislated in the Plant Improvement Act. Those inconsistencies are not satisfactorily dealt with. They need to be. But I think what is important is that we must appreciate that hemp is just a word, or rather a phrase, a type of use of cannabis, being that's used for industrial purposes. So as I said earlier, hemp is cannabis, it is dacha, it is umia, it is nsango. This is one plant, whether we're using it for rope or for dope or for whatever else, it's one plant. And it is unfortunate to see these references between cannabis and hemp because it's reminiscent of apartheid. And yeah, we are seeing a new form of apartheid, which is plant apartheid. So it's important to realize that the industrial, the Amapondo are using, as I mentioned, cannabis for industrial purposes. Their varieties of cannabis have more THC than 2% and more than 0.2%. So, and we said this in our written submissions, Chair, is this government genuinely trying to say that the Amapondo must destroy their ancient genetics that they have been the custodians of for hundreds of years? They are the holders of that indigenous knowledge. Must they now destroy those cultivars in favor of imported hemp varieties from Canada, from China, from France, as Chief Deco mentioned, how much the hemp industry is said to be worth in China. In fact, the shirt that I'm wearing is made out of cannabis, but unfortunately, this cannabis had to be imported from France into South Africa to be made by a South African company, whereas we've got hundreds of thousands of tons of industrial cannabis in Pondoland right now as I'm speaking to you. So we have to beg the question, Chair, whether this bill is fit for purpose. We submit that it is not. And to conclude, Chair, the privacy judgment from the Constitutional Court indeed allows all adult South Africans to cultivate a reasonable amount of cannabis for private consumption. This bill really was, or rather the judgment was celebrated the world over by many South Africans indeed as well. As we're seeing, the comments submitted are very substantive from civil society, and in the purpose of the lawmaking process and why public participation is so critical is that those that are affected by legislation, they know how they will be affected because they have been affected for the last 100 years only that cannabis has been prohibited. So we would then, to finally conclude, Chair, submit that the Portfolio Committee consults with the National Executive and indeed with President Ramaphosa to see and align the process that the President has recently spoken about in his State of the Nation address, which seems disjointed with this Cannabis for Private Purposes bill, which, with all due respect, is rather late to the party. I would like to thank you very much, Chair, for this further opportunity. We do indeed appreciate the lengths that this committee has gone to enable public participation. Thank you very much, Chair. I'll welcome any questions.
Thank you very much for the presentation. Members, are there any questions or comments? I think your presentation is clear. And I want to reiterate that the previous comments you made in other presentations relating to this bill, they still stand. We want to agree with you. When we finally do the consultation, we still have those transcripts. We will go back to all of those comments that we made as we are finalizing the bill.
Thank you very much, Chair. That is appreciated.
Thank you very much. Let's go to the next presenter. Let me just see, can you assist me here? Who is the next presenter? Thank you. Ignited.
Yes, thank you. Thank you, Chair, if you can hear me. I just want to get an indication that you can.
We can hear you.
Okay, thank you. Thank you, Chair. And it's an absolute privilege to sit here as a farmer and address a Portfolio Committee of Parliament. And I thank you for the opportunity. Very briefly, I am only going to comment on the hemp section of the bill. And I come from a background as a hemp farmer. We had the privilege to farm industrial cannabis since 2018, first under a SAPRA guidelines and then more recently under the Department of Agriculture, purely for research and demonstration purposes that we were doing it. And this has given us quite a deep understanding of the complexities of the cannabis sativa plant and all its products. We have done throughout the years extensive cannabinoid profiling at varying growth stages of a range of both local and imported genetic material. And these sampled plants were grown through different seasons and in different conditions. This research has highlighted the complex nature of the plant and the practical implications of tracking cannabinoid content throughout the growth cycle of the plant. We also identified a range of desired traits in African landrace cannabis varieties that compares with some of the best hemp landraces in the world. And I can really vouch for that because that has been our focus right from the beginning, to continuously compare and sometimes having to bend the guidelines to do that, to continuously demonstrate and plant African landrace seeds as we could get our hands on it, and comparing it to imported and also landrace varieties from other areas of the world. And we do find an amazing comparison. And also my experiences of industrial cannabis overall in the industry, and also my understanding of the history and the social construct of dacha smoking and farming in South Africa. I want to make the following comments with specific references to the amendments to include hemp. First of all, I think that the farming of cannabis for industrial purposes has no place within the private purposes bill. The Constitutional Court ruling by interpretation includes the growing of industrial cannabis for personal, non-commercial purposes. We cannot argue that if you want to grow cannabis to grow your own home, and that would need 1 or 2 hectares of hemp plants, that it is covered under the Constitutional Court ruling. Commercial cannabis farming in all its aspects should be seen as primary agriculture and therefore regulated by the Department of Agriculture, Land Reform and Rural Development. In my opinion, there's no botanical or scientific basis to separate the cannabis sativa plant into distinct species based on the cannabinoid content. Industrial cannabis, or hemp as it's called, should be defined as a product from the plant. And we need a fresh Afrocentric approach to allow existing genetic material to be legitimized into the formal agricultural system. Our farmers must be able to utilize indigenous and naturalized cannabis varieties for industrial purposes. This will unlock further research and breeding and the potential of South Africa exporting our unique genetic traits to the world, with the necessary benefits going to those deserving of it. And I honor my colleagues that spoke before me for the path that they have walked in bringing us to this point. On that point of including the rural farmers, I want to bring up that the fact that the cultivation of hemp is regulated under the Plant Improvement Act. That act, even for me, as quite a sophisticated farmer, is a complicated and daunting document. And I just see my colleagues stumbling over it as we go forward. And if it's going to stay there, we need an extensive agricultural extension program to implement this out in the field. I think the industry can be allowed to regulate itself, which includes the continuation of existing improvement of genetic material, like we have also demonstrated and proven through the past 5 years that we were able to do under the very restricted conditions that we were farming hemp under. I further feel that the products from hemp cultivation should be regulated within their sectors. Grains in the grain sector, food and beverages, engineering, textile, traditional medicine. And that include those aspects of the plant for adult consumption, which I feel should be regulated like alcohol for now, which for us from the industry is actually a compromise because we know that we can prove less harm. But if we assume the same harm, I think we can, in the interim, because I reject the bill in its entirety, and I want to come up with a solution, urgently go and find within existing legislation those places where we can regulate the products of cannabis and regulate adult use cannabis for now, like we regulate alcohol, which will allow us the space to really go back to the drawing boards And I understand the political and procedural restrictions and the timelines that we are faced with. But I would suggest that we go completely back to the drawing board, get some interim guidelines in place, scrap the plant off the Drugs and Drug Trafficking Act, and allow government and the private sector and everybody involved the space to create a cannabis for all purposes bill that we can compare with the quality of our constitution, which is something that we're really proud of all these years later. And we can honestly say out in the world that we have the best constitution in the world. Can we not use the time in the future, even if it's going to take 5 to 7 years, to come up with a best cannabis for all purposes act in the world? Thank you for the opportunity.
Thank you very much for the presentation. Members, that is the presentation that we have received from Ignited. Honorable Nego Druchen.
Thank you, Chairperson. Thank you to Mr. Ferreira for your presentation. I just wanted to understand, you were saying at the beginning, you were saying that the African seeds, African cannabis seeds, and the imported seeds, we were talking about that. So what is exactly the difference between the two seeds? Why is there so much controversy within the seeds? I always assume, we always want to use our own seeds here in South Africa. So can you maybe just clarify with regard to the seed issue so that I can get a better understanding? Thank you, Chair.
Okay.
Thank you.
Can I respond, Chair?
Yes.
Okay, thank you, Chair. If I can be allowed to share my screen, I can actually show you a picture that I took this morning, just comparing them in the field. So I can definitely talk from an agronomic point of view that imported non-adapted seed just fail and compare miserably to locally adapted seed. The problem at the moment is that we are forced under the Plant Improvement Act to only import and utilize certified seed that are certified based on cannabinoid levels in overseas conditions, which are completely dissimilar to our conditions. That can take a long time for me to explain the photoperiodism of the plant and how it responds to daylight, length, intensity, and other aspects of it. I hope that answers your question.
Thank you, Mr. Ferreira. Honorable Nego Druchen, are you answered?
Yes, I'm good. I'm good with that response. Thank you, Chair.
Thank you very much. Thank you, Mr. Ferreira, for taking the time to make the presentation. We know that it takes a lot of work to make such presentation, but it is for strengthening our legislative process. We would like to thank you for doing that.
Thank you.
Thank you very much. Can we now move to the next presentation, Cure Analytics?
Good day, sorry, Honorable Chairperson and members of the Portfolio Committee. My name is Ilse Ferreira and I'm speaking on behalf of CURE today. Please forgive me if I seem nervous in addressing this esteemed committee. CURE was established in 2019 to provide accurate, accessible and affordable cannabis analytics to a fledgling South African cannabis industry. As a first cannabis-specific analytical laboratory in South Africa, we have unique insights into the industry. Our customers range across the spectrum from SAPRA licensed growers and hemp farmers with permits to dispensaries, private clubs, healers, and private growers under the constitutional protection. Our management team is actively involved across most sectors of the industry, and we therefore believe that our comments on the Cannabis for Private Purposes Bill come from an informed and practical place. Our first point is the definition. There is no botanical or scientific basis to separate the cannabis sativa plant into separate species based on the cannabinoid content. Industrial cannabis, or the purpose for which it's used, or hemp, should be defined as a product from the plant. Cannabis can be used to produce many products across a variety of sectors, These products should be regulated within their sectors. For example, food, textiles, chemicals, energy, construction material, traditional and pharmaceutical medicine, and beverages. Responsible adult use of cannabis can be regulated similarly to tobacco and alcohol, like my colleague Nati said from Ignited. Regulations based on cannabinoid content cannot be enacted without detailed guidelines regarding sampling and testing procedures. The analytical industry in South Africa must be included in defining this before regulations are formed. Based on the above points of illustration and other inconsistencies and impracticalities within the tabled legislation, we do reject the entire bill, and we express the hope that the Portfolio Committee would seriously consider the voice of reason it has heard today from many of the speakers before me. Thank you very much for the opportunity to address you today.
Thank you very much, Ms. Ferreira. Members, are there any questions or comments? Honorable Jale.
Thank you, Chair. Ms. Ferreira is saying, Chair, is rejecting this bill in its entirety. I just want to find out, and what now if we don't have this bill? That's the question that I have from her.
Thank you, Honorable Jale. Ms. Ferreira.
Thank you for that question. I believe that we are able to slot cannabis into the various legislations that already exist. I think the private purposes bill should remain as it should remain private. We should be able to use cannabis in private, grow it in private, cultivate it in private without any plant counting, and that the bill should be really, it needs a fresh approach, as many of my colleagues have mentioned before.
Thank you. Are you covered, Honorable Jale?
Yes, Chair. Thank you.
Thank you very much. Thank you very much, Ms. Ferreira.
Morning, Chair. Morning, Chair. Can I intervene, please?
Is that Sia? Or is that Mr. Makubete?
It's Mukudubete.
It's Makudubete. Sorry for that. Yes, we can proceed. We can proceed.
Chair, can you hear me?
You are cutting. Just proceed.
Okay, thank you, Chair. My apologies for interrupting the session of the committee. However, I would like to make a follow-up question from what Honorable Maseko Jele has raised to Mrs. Ferreira. In terms of the counting of plants, obviously that aspect relates to the other part of the bill, and it's not confined to what the committee has invited comments on, particularly in relation to hemp. However, I want to raise a question regarding the counting of plants, because what we have done as a department and what the parliament is processing is a bill that intends to comply with the Constitutional Court judgment, in terms of which certain quantities that must be determined by parliament should be set as the quantities enough for personal consumption by an adult person. Now, obviously that also extends to the cultivation, in terms of which we are allowing 4 plants for cultivation purposes in private spaces of persons. Now, I would like to find out, instead of having the counting of plants, what would Ms. Ferreira suggest? Because now, Constitutional Court didn't set the number or the quantities that are sufficient for personal consumption, and it left that for Parliament, which is what Parliament is doing. What now will be sufficient for personal consumption or cultivation in their private, in the adult person's private spaces? Thank you, Chair.
Thank you very much, Mr. Makulubete. Ms. Ferreira?
Thank you for that question, sir. I believe that the counting of plants is unnecessary. The setting of quantities is unnecessary. If the person is using cannabis for their own personal consumption or personal use, whether that be growing hemp for seed, for making pesto, or whatever the case may be, there is no scientific basis to say that 4 plants is the ideal amount of plants. I would like to counter, if respectfully, if possible, what is the scientific basis of having a certain quantity in any use of the plant? I think the private purposes bill is trying to establish a limit for how psychoactive we're allowed to go and how much we're allowed to use on a personal level in recreational, but the plant is not only used for recreational purposes. Our personal consumption can be for health, it can be for, excuse me, to make food, to make ointments for our skin. It can be for very many things. 4 plants will not be sufficient for that. There's no scientific basis for that. And we do not count the number of grapevines a wine farm, a Garagista has when they grow their own wine. Why should we count the number of plants for cannabis, respectfully?
Thank you very much. Mr. Dupré.
Good morning, Mr. Chair. Good morning, members of the committee. And we appreciate you giving us the opportunity to ask questions. And I've got a lot, but I'm going to restrict myself possibly to 2 questions. The first question is, what, according to you, is the difference between hemp and dagga? Number 1. Number 2, I get the distinct impression that you would like to argue, not you, Ms. Ferreira, but the previous speaker, Mr. Ferreira. But I assume the 2 of you are in the same room because I can hear his voice in the background. Just explain to me, do you regard or do you want to make an argument that locally grown cannabis is equivalent to the whole rooibos sage? Thank you.
Thank you, Mr. Dupré. Ms. Ferreira.
Honorable Chair, would it be okay if I invited Nati to join me in this conversation, as he is sitting right next to me, as Mr. Dupré has rightfully mentioned? He is also a director of CURE, and I believe he can answer that question better than I can.
Only to answer the specific questions asked by Mr. Dupré.
Thank you.
Yes, thank you, Chair, for that opportunity. And I want to refer specifically to the rooibos saga because I'm slightly familiar with it, but I'm sure Mrs. Ferreira is not as familiar. But we do have the opportunity here, I think, to look at similar indigenous rights being vested in communities, which include regional appellation for the word dagga, grown under certain conditions, like we've done with rooibos, like we've done with Karoo lamb, and like it's done with champagne from the Champagne region. So we do believe that there is various opportunities to not only market South African cannabis for all purposes as unique, but also to vest the rights within the communities that deserve it, which will open up big opportunities in this, I think. We can continue.
I think there were 2 questions. Are you sure you have answered the 2 questions?
First, the first question, I don't think was directed at me. What was the first question was regarding the definition. So, I think that was directed at CURE, the question on the definition of what we define as hemp. I think I did define it as just a product from the plant, but there's no basis for a botanical definition of that. But I think that was more an answer for CURE, Chair.
Yes, sorry. The scientific definition of the cannabis plant does not include hemp at all. Hemp is a legal term, really, because it's defined by what the law is of the area that you're in. If you're in Europe, it's different from when you're in America, and it's different from when you're in Malawi or South Africa. So I don't think the botanical classification makes provision for any cannabinoid levels. And I think that for specifically to the private purposes bill, whether a plant is so-called hemp or not hemp is very hard to determine and should not make a difference. The person will only know if his plant is hemp if he sends it for testing to a laboratory and is able to determine the THC levels, whether they are low enough or not.
Thank you very much. Mr. Dupree, are you fine?
Chair, thank you. I'm very, very tempted to ask more questions, but I respect your processes. And as I said, I apologize for interrupting. I know you allow us sometimes the leeway to ask questions. I've been recently requested to become part of this bill's team. So I will follow the cue from Mr. Makudubete, but thank you very much for that, Chair.
Thank you. So since this is, but let me put it this way, you will be, as part of the team, making responses to the comments made. So it would be good that by the time you leave, you do not have doubt in your mind. You know exactly what people meant because you are going to be responding. So don't suppress questions for the sake of procedure if you are not really clear in your mind. It would not serve the process any good for doing that.
Thank you, Chair. I'm going to abuse the process then, and I'm going to cut to the bone. The reference that we have, and we're talking about a criminal law bill, the reference that we have is the Constitutional Court. My main question is, and we need to address the judgment by the Constitutional Court. My main question is, how do you commercialize or legalize something that has been or was illegal up to this stage? I would really love to receive proposals in that regard, Chair. Because once or the first thing to take into consideration, it's not the sphere of activities of the Department of Justice and Constitutional Development. We are concerned about the criminalization of certain acts and not the commercialization. And reference has been made to wine farms and tobacco, but kindly remember that they are heavily regulated, and you are sitting now with an unregulated commercial activity. Thank you, Chair. I would just like to get a response to that. Thank you, Chair.
Thank you very much.
Chair, I would respectfully say that we are discussing the Cannabis for Private Purposes Bill and not commercial regulation. Although my references to the tobacco and alcohol industries was that they be amended to include cannabis appropriately. Each of those regulations already exist. They already make provision for a whole lot of regulation. And we have seen over and over statistics that prove that alcohol is far, far more harmful than cannabis is. We have never had a statistic of a death on the road for cannabis. We have those for alcohol. And I believe if we regulate cannabis no less than alcohol, just the exact same as alcohol, we'll already have a much better bill than we have right now with the private purposes bill.
Thank you. Mr. Dupree, your last one.
Thank you, Chair. And please excuse the pun, but I'm coming in green here because I've only recently been assigned to Mr. Makudubete's team to assist with this bill. But I would like to just understand what the overemphasis is on driving. And we're not talking about, or we're not restricting, or we're not allowing tests to be conducted in factories where people handle for long hours, 12-hour shifts at a time, heavy machinery that can not only cause serious accidents, but even death. Just explain that to me, please. The overemphasis on driving is a bit confusing to me at this stage. Thank you.
Thank you. Honorable Nebo-Tuchen.
Thank you, Chairperson. My apologies for interjecting. My apologies for interjecting. I wanted to use this moment to also ask Ms. Ferreira something, because she said there's a lot of statistics with regard to driving under the influence of alcohol, and there's no proof or statistics with regards to driving and accidents when under the influence of cannabis. So I quickly read through. It's a pity that they couldn't come to talk to us. I think Doctors for Life, in their presentation, there's a lot of statistics with regards to accidents from the use of cannabis, if I understand their presentation or submission clearly. In the back of my mind, I just did have the question of where do they get these statistics from? Is it from South Africa or overseas? So I'd like to ask Ms. Ferreira if she is aware, or if she knows and understands from Doctors for Life's presentation, if she's seen it, where do they get these statistics from when you are saying that there are no statistics or very low statistics of driving under the influence of cannabis? That's my only question. Thank you, Chair.
Thank you very much, Honorable Nebo-Tuchen. Honorable Chale.
Chair, I just want to go back to Mr. Ferreira, when he said something earlier when he was doing his presentation that this bill is not Afrocentric, it is Eurocentric. So I wanted him to explain that statement, at least in summary. Thank you, Chair.
What was the question? Sorry, there's some noise here.
I'm saying, Chair, earlier when Mr. Ferreira was making a presentation, he mentioned that this bill is not Afrocentric.
Oh, okay.
It is Europe, yes. So I wanted to understand from his perspective, if maybe you can give me a summary of that. What does that mean? Thank you. Contains.
Okay. Let's start with Ms. Ferreira. You answer the questions posed to you.
Let me first answer the question about the statistics. I am unaware of any statistics. I have not seen the Doctors for Life presentation. I'm not aware of where they received their statistics from, and I will stand corrected if they can show their statistics and the sources of those. Sorry, I forgot the first question. The emphasis on driving, it was just an example used because it's an everyday example that all of us work with. Not all of us work in factories. I do believe that we sit with a conundrum that the THC testing is, we do not have the ability to test current levels of intoxication with cannabis. It's not possible as far as I'm aware. And if somebody has had a smoke on Friday evening and the effects have worn off, nothing further is inhibiting them from performing their duties, then on Monday morning, their drug test will return a positive result and they will be deemed to be intoxicated, which is a problem with testing right now. That is the conundrum that we are sitting with. I'm not here to speak about the labor unions and the laws and how they should be changed. I do believe that I would urge everyone on this committee to listen to Myrtle Clark from Fields of Green for All, who will be speaking tomorrow. They have drafted a really full spectrum manifesto for cannabis reform, which I think is quite valuable. And then you were not.
Yes, okay. Can I answer the question? On that Afrocentric versus Eurocentric approach that was specifically referring to the hemp sections that's now included in the private purposes bill. And I was referring specifically to hold to any percentages, because that is a Eurocentric. And why I say there must be a differentiation is because of our long tradition of cannabis growing and the wealth of knowledge that is currently locked up in our rural areas in the growing of cannabis or dagga for all purposes. Whilst Europe, in Europe, it is a much more recent crop and that has been bred specifically because of prohibition. These varieties were bred to have very, very low levels of THC, high levels of CBD, but they're grown in areas where we've got daylight in excess of 20 hours per day, and also grown under a subsidized agricultural system in many instances, which we don't have in South Africa. So I think we're much better equipped to actually tell the world how to handle this plant as a crop for all purposes than what Europe is. And I think our approach has been led by international guidelines and regulations, whilst we have a wealth of knowledge and experience, and also from the legal fraternity to come up with an Afrocentric approach that can be an example to the world.
Thank you very much. Ms. Jelly, I think it's an old hand. Am I correct?
Old hands, Chair. Thank you.
Thank you very much. Thank you to Pure Analytics. Thank you for the presentations. All presentation will be taken into consideration when we do our deliberations as the committee. That brings us to the end of the public hearings for today. We will continue with the public hearings tomorrow, starting at 9, possibly until 1 or 2, depending on how fast do we move. Thank you very much. Members, I think you did receive a report yesterday on the NCCS that was circulated to yourselves. Can we deal with that report so that it goes to the House as soon as possible? When we were presented with this matter, we were told that the term expires on the 20th of June. So it would be better if we are able to deal with this matter before that time. The report was circulated to all members. Should I be correct that it should be taken as read?
Yes, Chairperson.
Thank you very much. Let me first check the quorum. 1, 2, 3. Six, 7. Yeah, we do have the quorum. Are there any corrections on page 1? Honorable Nibo Trohan.
Yes, Chairperson. Can we go to point 1? I see. Can there be some commas in that sentence just to make it more clear? So a comma where it says the minister must appoint 4 or more persons, comma, not in full-time service of the state, comma, as representative. So that just to make it more clearer. And then on point 5, the last 2 lines, all candidates' qualifications were confirmed and all candidates' criminal records were negative, comma, except two, which were cleared. Thank you, Chair.
Thank you very much. Any further corrections on page 1? Page 2? Page 2? Is there a mover for the adoption of the report as corrected? Honorable Masego Jele.
Chair, I move for the adoption of the report as corrected. Thank you, Chair.
Honorable Masego Jele moves for the adoption of the report as corrected. Any seconder?
Honorable Neo Drugen seconds the adoption of the report as amended, Chair.
Honorable Neo Drugen seconds the report as corrected. Honorable Glenis Breitenbach.
Morning, Chair. Thank you. We reserve our position.
The Democratic Alliance reserves its position.
Yes.
Honorable Yako.
Yes, also the EFF does reserve its position at the moment.
The EFF also reserves positions. Any objections? No objections. The report is agreed to. Members, just issues for Friday. We still agree that the meeting is physical. Am I correct?
Yes, Chair.
Yes, Chair.
Yes, because I think Honorable the Deputy Minister saw somewhere that the report is virtual. I think it's an old thing. So the report, the meeting will be physical. Can you take us through the logistics committee, Secretary?
Yes, thanks, Chair. We are going to issue out an analysis document before the end of today, Chair, just to give direction to extract issues from the oversight report, just to give direction to the meeting. We're in M314 in Mark's building, Chair. In Mark's building, we'll be starting, I think, at 9:30. Yeah, yes, Chair. Members will there's buses from the parks. Members will make use of the buses on the day, Chair. And we will just find out as to what time will the buses be returning to the parks, Chair. That's as far as I'm concerned, Chair. Thank you.
Thank you very much. So the analysis document, but it would be important to have to itemize agenda items which need to come to me today, so that when we have that meeting, we have itemized all the items. I need to finalize it today.
Noted, Chair. We will engage with the rest of the team, Chair. Thank you, Chair.
Thank you. Then the other issue, I'm proposing, members, that immediately after we are done with the meeting with the ministers, that we deal with that issue of the South African Human Rights Commission, so that Christine can make the presentation. We can deal with the issue of authorizing the advert, so that by the time we go to recess, we use that time to have adverts out to the members of the public. Yeah, that is so far what we have on our side. I will find members with the logistical arrangements and the issue of the South African Human Rights Commission.
Yes, Chair.
We're fine, Chair.
Thank you very much. Honorable Breitenbach.
Thank you, Chair. I'm fine with the logistical arrangements and with with the other issues discussed. I must, however, place on record, and I will again on Friday, place on record my great disappointment that the Minister of Justice does not find time to come to this committee and deal with these issues that we intend to raise on Friday. This is a meeting that has been coming down the road for a long time. It's a meeting that's long overdue. And we all understand busy diaries. We all have busy diaries. But that the Minister, given the circumstances surrounding the poor performance of both his department and Public Works, and the absolute appalling state of affairs that prevails in most of the courts and most of the buildings for which Public Works is responsible, can't find the time to attend this meeting, I find astonishingly disappointing. I think it's an absolute disgrace. And if I don't know if the Deputy Minister is on here, and if he is, then he should listen to this. And if he isn't, someone should tell him this, I'll tell him too. They must come prepared. I don't want anyone saying the Minister is not here, we can't answer, we'll defer, we'll come back and write nonsense. They must come prepared. But I'm really, really not happy that the Minister is not going to be there. Thank you, Chair.
Agreed.
Thank you very much, members. I think the meeting on Friday, it would have apologies and all of those things. We will deal with those issues at that time. But what I've been made to understand, but I think you can respond to that if you so wish on Friday, is that there is a standing meeting in France where the minister is the leader of delegation for the Republic, that he was delegated to lead that delegation by the president. So that is why he will be there. But I think let's discuss that and all of those things on Friday. Thank you very much, members. The meeting is adjourned.
Thank you, Chair.
Thank you.